Be seated, please. The next case on our docket is Century Professional Recruitment versus State of Florida Administration. We'll hear from the appellant.
Good morning, Your Honors. May it please the Court. My name is Chastity Osteen, and I represent the appellant, Century Professional Recruitment, Inc., doing business as Century Health Services. This time, I would like to reserve 3 minutes for rebuttal. This case involves the operation of home health agencies by Century under two separate licenses, the Broward license and the non-Broward license. And this is a consolidated administrative appeal of two final orders rendered by the agency that revoke Century's licenses and impose the maximum fines permissible. The issue is whether the agency, under its statutory scheme as applied to the facts in the record, has afforded Century appropriate due process before imposing the maximum penalty available in the administrative context, the revocation of Century's licenses, and the maximum penalties. The administrative complaints alleged violations of the same statutes and rules and were based upon the same factual allegations. Those center around whether Century was operating a drop-off site or a satellite facility requiring additional licensure. There were no allegations in the complaints that any patient of Century had been harmed, or that any person or entity had been deceived or defrauded by Century in its alleged allegations. A copy of each complaint was sent by certified mail to Ms. Hebert, Elizabeth Hebert, as registered agent of Century at her home address, and also to Ms. Hebert at Century's business address. In each case, someone other than Ms. Hebert signed for the certified mail return receipts. In the Broward license case, Century filed a request for a petition for hearing within 21 days of receipt of actual notice of the complaint, filed Ms. Hebert's affidavit attesting to the date that Century received notice, and further requesting a fact-finding proceeding to determine the timeliness of its petition, of the filing of its petition necessary. But without granting that hearing, the agency below determined that the petition was not timely filed, and further that the doctrine of equitable tolling did not apply.
Well, isn't the purpose of having a registered agent some kind of assurance that if you send something there, they get it, not some other employee diverts it, puts it in the bottom of a pile somewhere?
Well, that's exactly our point, Your Honors, that the agency is required to comply with the provisions of Section 48.081 for service on a private corporation. And under subsection 3 of that statute, yes, that is what the agency is required to do. In the alternative...
So your argument is they're required to get personal service?
If they choose so by certified mail, yes. That is exactly what, under 48.081, which has to be read in pari materia, with Section 120.605, with Section 120.60, subsection 5, the agency may serve by certified mail or by personal service. If the agency chooses to serve by certified mail, it must follow the process for service upon authorized agents of the agency, of Century, pursuant to Section 21.480.081. And in this case, that was Ms. Hebert.
Mm-hmm. How does that work as a practical matter? When you do certified mail, it goes to the right place and someone signs for it. But
it's actually very simple. If you look at the green card, a certified mail return receipt card, there is a restricted mail option. All the agency has to do is check that option, and that ensures that the addressee, which in this case was Ms. Hebert, would have received that certified mail. Even under the current process that the agency used, even if they didn't use restricted mail, check that box on the certified mail return receipt. The only evidence, the only competent substantial evidence in the record is that Century attempted service on Century. It didn't reach Century through its registered agent, Ms. Hebert, but it attempted it.
Was it sent to the correct address?
It was sent to the correct address, Your Honor.
And who signed for it?
The record doesn't state what that person's relationship is to Century. And that
It had to be somebody that worked there.
Not necessarily, Your Honor. And it is the agency's burden to prove if there is an agency relationship between the person that signed and Century. And that was something that this court discussed in Simmons versus State. In that case, the notice issues that this court addressed are on point. In the Simmons case, the agency attempted to serve the applicant. In that case, it was a license application by certified mail to the applicant's home address. It was returned unclaimed. Subsequently, the agency attempted service by certified mail and sent it to the person's employer. That person did, in fact, sign for that certified mail. But in reversing and remanding that case to the agency for a fact-finding proceeding about notice and agency, this court stated that that is an issue of fact and that there were insufficient facts in the record to establish an agency relationship between the person that signed and the applicant. And that's exactly the problem we have here, Your Honors. Further, the agency has acknowledged that the essence...
In this particular case, it's not the corporate entity that's under scrutiny, isn't it the individual's license?
No, I'm sorry, I did not mean to interrupt you.
Isn't an individual license not a corporate license?
Actually, Your Honor, Century, the corporation, is the licensee. It is not Ms. Hebert.
It's not the individual.
Correct. That is correct. But there's no distinction for purposes of the issue of notice that this court addressed in Simmons. So there's no distinction between the facts in that case on that basis and the facts in this case. The court indicated that there might have been implied actual notice of receipt in the Simmons case, and that is what the agency is attempting to prove in the cases below, but they have failed to do so because there is no evidence in the record about the relationship in the non-Broward license case, about the relationship between those who signed and Century, the licensee. And in the Broward license case, Your Honors, we actually have Ms. Hebert's affidavit, which affirmatively establishes that those who signed for the certified mail in that case were not authorized to sign on behalf of Century.
What about the fact that they sent a copy of this administrative complaint to her business and to her home address? What happened to the one that was sent to her home address?
Someone signed for those in one case.
In her home address?
Yes, Your Honor.
And is there anything in the statute in 12065 that mandates the requirement that the addressee sign?
Your Honors, certified mail has to mean something. It has to mean more than an attempt to serve.
Certified mail means that it got to where it was going, and somebody noted that it got to where it was going. Somebody signed for it.
That's correct, Your Honor. But it also means that there are two ways that an agency may serve under Section 120.60 subsection 5, and that is by personal service or by certified mail.
Sure, but where in 12065 does it say the addressee has to sign for the certified mail and not somebody at the addressee's address?
Well, that is what is required by due process, Your Honor. And furthermore, in this case where a service is being made on a private corporation, the agency is required to ensure that someone that is authorized by that licensee, by the private corporation, receives notice. It's the receipt of notice that triggers the 21-day time frame for receipt of notice. So the agency's argument is that if it sticks a complaint in the mail, it checks off the box that it was mailed and that it was received by someone, that constitutes service on a private corporation whose license that agency is trying to revoke, whether it was the registered agent of the licensee or just some random person. It could be the janitor. It could be the housekeeper. It could be somebody visiting from out of town, Your Honors. The agency has acknowledged that the essence of due process is notice and the opportunity to be heard. Yet it is the agency's position that Section 120.60 subsection 5, and I quote, does not require the agency to ensure that its certified mailing is received by the appropriate person, and to demand an agency to do so would be an unreasonable burden. That interpretation of the statute is erroneous. Simmons is on point for the proposition that the agency must at the very least show that the licensee, in this case Century, received actual implied notice and they have failed to do so. There is not competent substantial evidence in the record in this case, in the non-Broward license case, that about what the relationship of those persons who signed were to Century, and that they were authorized to sign. And even so, if there was an agency relationship, and that is what the court in this court, in Simmons v. State, said is required to prove actual implied notice. Furthermore, in the Broward license case, we have Ms. Heiferd's affidavit, which expressly states that the persons who signed were not authorized to sign on behalf of Century, and that Century received actual notice of the complaint on June 14th, which was not the date that the person signed for the certified mail. There is, furthermore, in license revocation cases, ensuring that the appropriate person receives the certified mail is what Section 120.60 subsection 5 requires to ensure due process. In Buckman v. State Board of Accountancy, the Florida Supreme Court held that statutes permitting the revocation of occupational licenses are penal in nature and must be strictly followed. Section 120.605 requires that the agency ensure that the licensee whose license the agency is attempting to revoke receives notice. Furthermore, it would not be an unreasonable burden for the reasons previously stated. All they'd have to do is check for restricted mail on the return receipt, and if that didn't work, Your Honors, the agency always has the option to use personal service under Section 120.60 subsection 5. Furthermore, the agency has taken the position that Section 48.081 Florida statutes does not apply in administrative license revocation cases. At one point in the proceeding below, the agency actually asserted that it had complied with Section 48.081. So if that was the agency's position, I don't know why it would have made that assertion. But nothing in the APA or the administrative code instructs the agency about how to serve a private corporation. That information is found in 48.081. And that is what the agency is required to follow. Century does not argue that the agency cannot use certified mail, and that is in fact consistent with what this court stated in Shelley v. State of Florida Department of Financial Services in 2003. But that does not mean that service by certified mail is de facto legally sufficient to effect service in every case. If that were true, and an attempt was all that was necessary, this court in Simmons v. State would have found that the agency's attempt to serve the applicant in that case by certified mail was successful, even though it was returned unopened. Unless the panel has any additional questions, I would like to reserve the remainder of my time for rebuttal. Thank you.
Good morning. May it please the Court, my name is Tracy Cooper, and I represent the Agency for Healthcare Administration, the APHLE. Let's see if we can clear up a few things here. First of all, Chapter 48 does not apply. That statute specifically governs service of process in civil cases, not administrative cases. The APA governs administrative cases. So 48 really doesn't help us. Another thing, the agency actually did more than we had to here. All we had to do was serve them by certified mail. That's all the statute requires, certified mail or personal service. Here we actually served them at two addresses. We served their corporate address and we served their registered agent's address. There's nothing that requires us to serve their registered agent's address. All we have to do is serve them at the address of record that they have to keep on file with the agency. There's actually rules that say that a licensee has to keep us updated as to the address.
How do you distinguish this from Simons, the case where this court said, look, certified mail is okay, but you have to send the certified mail to the person who's the subject of the order. And in that case, it was clear that the person that was the subject of the order didn't sign for the mail, and it required an evidentiary hearing to determine if they actually did get the notice. Why is it that, second question, that we we should consider certified mail as not requiring that the person actually receive notice.
Well, Your Honor, first of all, certified mail does not leave an opportunity for the person not to receive notice, as far as is my understanding of the U.S. Postal Service's requirements established. I mean, that all it does is it shows that it was delivered at the address of record. Statute requires us to deliver at the address of record. Summons is not is actually distinguishable, because that was a case in which...
So that would be no different from the procedure we used to have many, many years ago of tacking a notice on the door. Doesn't have to go to the person, just has to...
Well, no, it's a rebuttable presumption of receipt, okay? They haven't shown anything here saying... I just don't... Certified mail is actually... Okay, let me back up. It's not really rebuttable presumption of receipt. Certified mail is proof of receipt. There are cases, perhaps when there are extraordinary circumstances. However, this was a case that wouldn't meet those requirements. I mean, we served them at both addresses. Not only that, Ms. Hebert admits that she got the certified mail in at least one of the cases in plenty of time to file a response, and she did nothing. She didn't call the agency. She didn't attempt to to file a petition on time. If this is a case where the petitioner slept on its right.
Continue with your distinction of Simmons.
Simmons, the key word in that is person. Simmons was an individual. This is a corporation. Simmons did not give us, they gave the agency the address of their employer. But, obviously there were many employees there. Here, we served the corporation. The corporation includes everyone at the corporation. The rules of service on a corporation and civil procedure rules don't apply. There are rules saying we have to send it to their address of record. That's what we did. I think it's very obvious here that they actually, Century actually did receive service. I mean, they have not disputed the delivery dates on the certified mail return receipts. They admit that they received, in the affidavit, they admit that Ms. Hebert had that administrative complaint 13 days before a response was due. I really don't know what else they want us to do here to correct. Century waived its right to dispute the administrative complaints. In one case, they didn't even file a petition for hearing at all. Not late, not otherwise. I would say that that's a pretty conclusive case of kind of defaulting, of waiving your right.
Of course, their argument would be that there would be no default because they could wait 20 years to file a response, because if they didn't receive it through certified mail, it wouldn't matter because the time never began running.
You're exactly right, Your Honor. There's a big public policy argument against their interpretation of the word receipt. Plaintiffs could simply say that, well, the appropriate person in our office didn't get it. Our internal mail procedures didn't work, but agency, you're responsible for making sure it gets there.
Could they have somebody else be for it other than the registered agent, which would satisfy the statute, but wouldn't satisfy their claim that it has to be the exact person identified?
Right. I think that there's with Century's interpretation, there's a great possibility for avoidance measures. The agency would never be sure of the actual date of receipt. There'd be lots and lots of disputes about this. Whereas with certified mail, we know when they got it. They know when they got it. Everybody's aware. If there's a dispute, they can tell us, hey, we don't think we received it on that date. We don't think we received it in time, which they did here, but at the same time, they didn't show that equitable tolling applied because they showed that they slept on their rights. There's kind of a two-part thing. You have to not only, for that to apply, you have to not only be late, but you have to also show that you did everything within your power, that you were somehow lulled into an action by the agency, that you asserted your rights in the wrong form. That hadn't happened here.
Well, they waived equitable tolling below, didn't they?
Yes, they did, Your Honor. They didn't preserve it for appeal. As a matter of fact, in one case, because they didn't file a petition, there was no equitable tolling assertion. In the other one, they specifically said in their response to our order to show cause, directing them to show why equitable tolling applied, that they didn't need to rely on equitable tolling, that they didn't think that it applied. I don't know how they can assert it on appeal, but at the same time, I felt it was necessary to address it. You know, this whole issue of implied actual notice, I think certified mail pretty much fits the bill. That's what you do. That's, you know, there's an opportunity to show that you didn't get it, but certified, I mean, you have a government agency saying, the U.S. Postal Service saying, hey, they got it. Somebody signed for it. Unless this court has any other questions, I think that I've talked about everything I needed to. Thank you very much. I rest on my brief.
First, Your Honors, the agency is taking the position that Century has waived their right to a hearing. So therefore, the agency has the burden of showing that Century received notice, and they have failed to do so in this case. Due process requires that the appropriate person, the party whose license the agency is seeking to revoke, actually receives the notice, the complaint, not just somebody.
Whose license are they trying to revoke?
Century's, Your Honor.
Okay, so it's a corporation, it's not a person.
Yes, Your Honor, and the Florida Supreme Court has actually stated in Smetal Corporation versus Westlake Investment Company in 1936 that a corporation is a mere incorporeal legal entity created by government, and personal service on a corporation means personal service on the officers or agents of that corporation. Applying the standard in the license revocation case using certified mail, the agency's attempt to serve Century does not meet that standard. In this case, Century's registered agent and officer was not served and did not receive receipt of either complaint by certified mail. In the Broward license case, and to correct a misstatement by opposing counsel, Century did receive the complaint in the Broward license case, and in that case, within 21 days of receipt of notice, did file a petition for hearing. The burden in the non-Broward license case is on the agency to prove that notice was received. The only evidence in the record in that case is the certified mail return receipts themselves, which establish that, in fact, Century did not receive service. They were not signed for by Ms. Hebert. And again, that burden is on the agency. They're trying to shift the burden to the licensee here, and that is not correct, Your Honors. Furthermore, the election of rights says that the licensee or any person whose rights are substantially affected by proposed agency action has 21 days from the date of receipt of written notice. In this case, Century did not receive notice in the non-Broward license case, and it did file a request for a petition for hearing in the Broward license case within 21 days of receipt of notice, as stated in Ms. Hebert's affidavit, which was filed in the proceeding below in that case. If anyone would do, Your Honors, why did the agency mail it to Ms. Hebert at her home address to begin with? If anyone would do, why was the mail addressed to Ms. Hebert at Century's business address? There would have been no need for the agency to do so. Thank you, Your Honors.